Before this hearing even begins, pay close attention because this is one of those courtroom exchanges that starts off looking simple and quickly turns into a battle of wills. On one side, you have a judge trying to move a negotiated plea agreement through the system. On the other, you have a defendant who already has a serious criminal history, is currently serving time for murder, and appears determined to challenge nearly every step of the process. What makes this case fascinating isn't just the charges, it's the growing tension over something that sounds straightforward. How exactly should the defendant enter his plea? As you'll see, the defendant repeatedly insists on pleading no contest, while the judge repeatedly explains that, under the circumstances of this plea agreement, she is only willing to accept a plea of guilty or not guilty. What follows is a remarkable back and forth that gradually escalates from confusion to frustration and eventually to outright courtroom sarcasm. But beneath all the tension is a very serious legal reality. The defendant is facing charges that, combined with his criminal history, could expose him to a significantly harsher sentence if he rejects the deal and takes his chances at trial. Watch carefully as the judge repeatedly warns him about the consequences of going forward. Notice how defense counsel attempts to keep things moving. And pay attention to the moments where the defendant believes he understands the law better than everyone else in the room. Those moments become critical as the hearing unfolds. The biggest question is this: is the defendant standing up for what he believes are his rights, or is he sabotaging a deal that could save him from a much harsher outcome? By the end of this hearing, we'll see exactly how the judge handles the resistance, whether the plea agreement survives, and why one sarcastic exchange later in the proceeding completely changes the tone of the courtroom. Let's get into it.
Victor Campbell, Mr. Parker. Okay.
He knows a lot better than me. He's already in prison for murder. Out of another county.
But he signed it, but he
Yes, I'm just saying.
Okay.
I don't know how
it could be
he wanted to say no contest. He wanted to different things the law was to you. Oh, yeah. Did Philip sign them?
Mm-mm.
I'm sorry, Judge. You were thinking fully laws, yeah.
Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Well, you are?
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 3051.
And are we going on all of the counts or?
No, not on. We need to go on, well, in 36426, he will need to be true to the one enhancement paragraph in the indictment
Okay,
and, count one only in the other. Right.
all right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge?
Okay.
So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
But
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no content because he never even went over the indictment with me.
Yeah.
I find that hard to believe. So here's the
To
thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture
in
one
Beaumont.
here.
Yeah.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment after.
Sir, the
That's
allegation,
why I'm pleading no contest.
I'm not going to
I
allow.
find guilty. It's fine.
Here's the thing, I don't have to accept any plea agreement,
Yes, ma'am.
okay? So you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual, you're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not gonna accept the disrespect. If you want me to follow this
Let's pause
agreement
here because the
and
judge
go
has
along-
just laid out the most important legal reality in this entire hearing. She's explaining the difference between today's negotiated plea agreement and what could happen if the defendant decides to gamble at trial. Based on the enhancement allegations and prior convictions, the sentencing exposure becomes dramatically higher if he's convicted after trial. That's why the judge keeps emphasizing the phrase, 25 to life. Now, notice something else. This isn't just about legal procedure anymore. The judge clearly feels that the defendant's behavior is slowing down a process that could actually benefit him. From her perspective, she's offering a path to resolve these cases under a negotiated agreement. From the defendant's perspective, he seems focused on procedural concerns and his insistence on entering a no-contest plea. Here's a question for you. If you were facing a potentially much longer sentence at trial, would you focus on challenging the process, or would you take the deal and move on? Let us know what you think because this hearing is only getting more intense from here.
Along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not gonna show disrespect while we're doing it, to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea
If
agreement.
you go to trial, listen to me. If
Yeah,
you go to
fine.
trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. You saying assault family violence. The invading arrest is I
Listen.
plead guilty.
It's evading arrest or detention
But
with
what
the
are you
use.
looking at? I'm saying
I'm
Look,
looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you
Right.
you were
Hold on,
convicted of
this,
something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way. Give me just a second. Which one is being dismissed? 5-1 or
39051.
okay.
Make sure you don't get my information mixed up with his.
Who's?
Or whoever that information is. I ain't gonna say his name on the record.
That's not me.
Just a second. Well, it's taken care of. I should have 2 indictments. So just please.
What we're witnessing now is a courtroom that has essentially gone in circles. The defendant continues returning to the same argument regarding the indictment and his preferred plea, while the court keeps redirecting him back to the central issue, guilty or not guilty. This is actually a good example of how courtroom proceedings differ from everyday arguments. A courtroom isn't a debate stage where participants can continuously revisit topics that have already been ruled on. Once the judge has made a decision regarding how the plea will proceed, the hearing must move forward within that framework. Notice the patience being exercised here. Documents are being physically placed in front of the defendant so there can be no confusion about the charge being discussed. The court is attempting to remove every possible misunderstanding from the equation. Yet despite those efforts, the disagreement remains exactly where it started. And if you think the tension is high now, wait until the defendant starts challenging the judge's legal explanations directly. That's where this hearing takes an especially dramatic turn.
All right. Place that in front of your client, please. Now, that is cause number 21-36426. That indictment alleges in paragraph 1 that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not, you plead guilty or not guilty.
So if I'm telling you no contest, what is that?
It's nothing and it's nothing. You're not allowed, I can take a plea of no contest or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again,
This
guilty
is
or
a
not
critical
guilty.
legal moment.
Period. That's
The
your
judge is making it crystal clear that a no-contest plea is not something a defendant can simply demand as a matter of right in every circumstance. Courts have discretion regarding whether to accept certain plea arrangements, particularly when a negotiated agreement is involved. What's fascinating is that both sides are talking past each other. The defendant keeps returning to what he wants to plead, while the judge keeps returning to what she is willing to accept under the agreement. Neither side is changing position. You can also hear the frustration building. The judge has now explained the same concept multiple times, and each repetition increases the tension in the room. For viewers unfamiliar with court proceedings, this is often where patience becomes a major factor. Judges are expected to ensure defendants understand what is happening, but they are also responsible for maintaining order and moving cases forward. Do you think the judge has been patient enough at this point, or should she have simply set the case for trial much earlier? That's a debate many viewers are probably having right now.
I'm
That's
about
saying
to
that
set
I'm
your
not-
case for
that's
trial.
saying that I'm not. That's basically saying that I'm.
We're not going to
guilty
argue the
or
law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue
ahead.
the law
Fine,
with
no
you.
guilty. Just sign. Go ahead.
I
Put it
don't-
as guilty. Go ahead. That's what y'all want anyway. That's fine.
Listen.
I'm cool, ma'am. Just go ahead. and
Well,
get
you're
the
not.
guilty.
You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the
It
guilty.
nothing here.
Plead guilty. There
Okay,
you go.
so you plead guilty to evading arrest or detention
Yes,
with the
ma'am.
use of a vehicle. Okay, the next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence, December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same
That's
case
okay.
as far as
Look-
evading arrest, ma'am. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly, and that's,
that.
listen, so Mr.
That's
Campbell, that's,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea
And there it
agreement,
is, the
it's
moment that
repeat.
completely changes the atmosphere in the courtroom. When the defendant suggests he might be able to help the judge do her job, the exchange instantly shifts from tense to openly sarcastic. Now, let's be fair. The defendant clearly believes he understands the distinction between a repeat offender and a habitual offender enhancement. However, the judge is focused on the practical reality of the plea deal being offered versus the risk associated with trial. That's why she keeps steering the conversation back to sentencing exposure rather than theoretical legal arguments. What makes this moment memorable is the clash of confidence. The defendant is confident in his interpretation. The judge is confident in hers. But only one person in the room has the authority to decide how the proceeding moves forward. This kind of courtroom exchange often goes viral because viewers immediately choose sides. Some see a defendant standing his ground. Others see someone making an already favorable situation unnecessarily difficult. Which side are you
I
on?
understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay, so I have well, let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no contest, but guilty now.
So are you pleading guilty to this charge?
Yeah.
Okay.
Unfortunately.
And did anybody force you to plead guilty in cause number 22-39050?
We just answered it.
I know, I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
I just pleaded guilty.
Okay, and nobody forced you to do that, right? Speak up so the record can take it
No,
down.
I think you did. You did, but let's go. So no.
Now that the guilty pleas have been entered, the hearing moves into a much more procedural phase. This may sound routine, but these questions are incredibly important. The judge isn't asking whether anyone forced him to plead guilty just for conversation. She's creating a clear legal record. If a defendant later claims that the plea was coerced or that he didn't understand what he was signing, courts will often look back at exchanges exactly like this one. That's why the judge carefully asks about the documents, whether he reviewed them with counsel, and whether he understands the rights he is giving up. Notice how detailed the process becomes. Every answer matters. Every acknowledgement matters. Every signature matters. It might seem repetitive to viewers, but these are the safeguards designed to protect the integrity of the plea. The irony here is that after spending much of the hearing arguing about the plea itself, the court is now building a record to ensure that same plea can withstand future legal challenges.
Okay, so I have in both of those cases here on the tablet, some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
Understand what we signed, the document.
Okay, you have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed, okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal, and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest could result in your deportation? If you're not a U.S. citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Another important legal checkpoint has just occurred. The court addressed competency, which is a fundamental requirement in criminal proceedings. A defendant must be mentally competent to understand the nature of the proceedings and assist in his defense. This isn't the court insulting the defendant or questioning his intelligence. It's a legal safeguard. Before accepting a plea and imposing a sentence, the court needs confidence that the defendant understands what is happening and the consequences that follow. What's interesting here is the contrast. Throughout the hearing, the defendant has been actively challenging legal concepts, questioning procedures, and expressing his opinions. Whether viewers agree with him or not, those interactions likely contributed to the court's conclusion that he understood the proceedings. We're now approaching the moment where all the arguments, interruptions, and negotiations finally lead to a formal judgment. After all the resistance, we're about to find out exactly what sentence the court imposes.
So what this is, so I don't,
I'm required to ask everyone that. Are you a U.S. citizen?
yeah,
Okay. State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're gonna.
you said.
I just printed the wrong thing.
She asked me if I thought that there's evidence you weren't. I said, no, there's not. He's confident.
I just printed the wrong stuff. Did I print both of the
Give him the
certifications?
thing on that.
Sure.
Please.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, fell, please. I ain't drinking,
Mr. Campbell, you ready?
Yeah,
In cause number 21-36426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
so can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that how long I've been in custody.
I don't know.
I've been
I don't
in
have that
custody going on
information.
5 years.
Okay, you'll get all the credit that you are entitled to get by
3
law.
months.
And cause number 22-39050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
The sentencing phase is now complete, and there are several important details worth highlighting. First, the defendant received 18 years on each case under the plea agreement. Second, those sentences are running concurrently, which means they are served at the same time rather than one after the other. That's a significant distinction because consecutive sentences could dramatically increase the amount of time involved. The court also dismissed an additional case as part of the negotiated resolution. Again, that's another reminder that plea agreements often involve compromises on multiple fronts. Notice how the defendant immediately shifts his attention to jail time credit. That's not unusual. For many defendants, understanding exactly how much credit they receive for time already served can have a major impact on their projected release calculations. At this point, the legal battle is essentially over. The paperwork is complete, the pleas have been accepted, and the sentence has been imposed. All that's left is to reflect on how we got here.
These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 22-39051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
They
sir?
have it in the jail.
Excuse me?
No, they have it at the jail. No. I told you.
You didn't tell me.
Why he wasn't that bad?
I mean, this one might be difficult, and Judge, this one's really gonna
He-
push you over the edge. Difficult.
What a remarkable courtroom hearing. What began as a straightforward plea proceeding evolved into a prolonged debate over plea terminology, indictment issues, sentencing enhancements, and courtroom authority. Throughout the hearing, the judge repeatedly emphasized that the defendant faced a choice: accept responsibility under the negotiated agreement or risk substantially greater consequences by proceeding to trial. Despite multiple disagreements and several moments of visible frustration, the court ultimately accepted guilty pleas in both cases. The defendant was sentenced to 18 years for evading arrest with a vehicle and 18 years for tampering with physical evidence, with both sentences running concurrently. An additional case was dismissed as part of the agreement, and the court formally documented the defendant's waiver of appeal rights under the negotiated plea. The broader lesson from this case is that courtroom proceedings are often about far more than guilt or innocence. They involve strategy, procedure, risk assessment, and understanding the long-term consequences of every decision made. Whether you believe the defendant was protecting his rights or unnecessarily complicating the process, one thing is certain. This hearing provided a fascinating look at how plea negotiations play out in real time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.